All right, we should be live right now. Sorry, I'm getting distracted by the wife in the kitchen. Hey, this is 2025. We don't believe in that. You get out of that kitchen right now. See, the people love me. Anyway, here's the awkward part of the stream where I just got to skibbity bop for about a few minutes while people get in here. But let me get the link. I want to see the first person who gets in here. Hold up. Here's the awkward part of the stream where I just got to skibbity bop for about, first person in here who leaves a comment, you get a cookie. Alright, I gotta tweet this out. Anyway, yeah, we just chilling. Oh, Blasian China fashion, first one in here. Heck yeah, good to see you. Thanks for being here. Yeah, we're just gonna hang out for just a few minutes. I'm not waiting too long before we start watching this because day one of this Cardi B trial is the recording I've got is 3 hours long, so I'm gonna watch it on a little bit of a faster speed than normal. But we're gonna get through it together because there's a lot to break down. Okay, let me go ahead and tweet. Actually, let me change this too, so y'all can let me share what I'm looking at here, because we're all one big happy family. We're live now. Boom. Cool. All right. Already y'all can tell stream number 2, improvements being made. In chat, you can now see it. So you can see yourselves talking. And yeah. Little by little. Making improvements little by little. But so far, even if it's just Blasian China fashion, how's it going? How's your week? It's Friday. It's the weekend. It's a long weekend too. It's exciting. I'm still fiddling with my last few settings. Yeah. Okay. Coolio. Who's what are y'all's involvement with the Cardi B trial so far? Y'all been keeping up with it? Because a long week deserves a long weekend. Hey, I'll drink to that. Boom. Do I know what kind of wine it is? No. I just know I have it, and I finished off the bottle. Because, yeah, it's the weekend. And we all deserve a little drinky drink. So if y'all don't have one yet, go ahead and get y'all some. Indeed. But yeah. So I wasn't planning on covering the Cardi B trial. But when I saw that the full trial was concluded after 3 days, I was like, yeah. Hold up. I got noises going. Okay. Yeah, that's fine. Yeah, whole trial was 3 days long, which I'm used to these trials being like 3 weeks long. So to be able to get it all done in 3 days, it's like, oh, definitely, this is something we can cover together. So that's what we're here to do today. Boom. Advertisements are out there. Been watching clips here and there. Honestly, that's kind of where I'm at right now. I've just seen some of the viral clips, but as someone who does this stuff day in, day out, yeah, I'm interested in diving into the meat of it. So that's what I've got here. But we're going to give a few more minutes, get a few more people in here. But in the meantime, yeah, for anyone who's new or watching the VOD back and is new to the channel, hello, my name's Scotty O, aka the Gen Z attorney. And I currently work in private practice doing litigation, so civil and criminal stuff. Used to be a prosecutor, but I've since gone private, and now I see a lot more in private practice, which is really cool, really fun. But yeah, use this channel to break down these high-profile cases. And what better case? You know, we don't get every day where a case featuring a A-list celebrity like Cardi B, who's as outgoing, shall we say, as eclectic, shall we say, as Cardi B. So definitely going to take this advantage to go through it. And the plan, too, by the way, is to do day one today. You know, it's a 3-hour video. I'm going to have it going faster, and I'm really not going to be interrupting it too much. I'll just try and basically be talking over it as necessary. But yeah, that's going to be day one. Day two, the plan is to stream that on Sunday. I would do that tomorrow, but I'm busy tomorrow, so Sunday we will be streaming that in full. And day three, we will stream on Monday, on Labor Day, which will get us caught up just in time for Tuesday, which is when the lawyers come back and they'll do their closing arguments, and the case will go to the jury to deliberate and decide on whether or not Cardi B is liable. So that's that's kind of where we're at as far as coverage plan. So if y'all are interested in watching this, then that's going to be, I'll be here. Hopefully I see y'all in there. But yeah. Hold on, let me pull up some background stuff. Okay, and we're public. There we go. Okay. Awesome. All right. Well, we gave a few minutes to folks. I imagine more will be trickling in as the stream goes on. So yeah, let's jump right in and watch the Cardi B trial together. So this is the opening statements. This is one of 2 times where the lawyers get to talk directly to the jury, and yeah, that's what's happening here. So let's examine and judge hardcore how the lawyers are doing. Oh gosh. See, this is how you know I didn't pre-watch this, because I didn't realize there's these technical difficulties in the video itself. Does this get fixed? Okay.
The moment I loved.
It does, but jeez.
Cardi never touched her.
The moment I loved our Subaru Outback most
Oh, thank goodness.
was the moment they
To both sides, that you hear all of the evidence.
Let's go. All right, let's get right to where we start hearing it.
Mistaken for,
Boom. Okay. It's pretty quiet. I'm going to turn it up to max volume.
mistaken for a lack of interest in the case.
Max as possible for me.
And this is a very important proceeding for her, but she is sick, so I apologize for that. This is the last opportunity I'll have to speak to you directly and tell all the evidence is in. This is my chance to tell you what I believe the evidence will be. Now, what I say and what counsel has said today are like promises. We're predicting, we're promising you what we're going to show, and at the end of the trial, and I want you to remember the promises, because at the end of the trial, I'm going to ask you who kept their promises and who didn't. Now, obviously, both sides can't tell their side of the story at the same time. That would be chaos. So in our system, the person who filed the lawsuit gets to go first. You've heard many times today that it's very important that you keep an open mind, that you hear both sides of the story before both sides.
Is this the judge talking right now, or the defense lawyer?
Before you make a decision or come to any conclusions. It is the only way to be fair to both sides, that you hear all of the evidence and not just jump to conclusions. Now, this is what we expect the evidence will show. First, Cardi is a loving mother to 3 young children.
Okay, definitely defense attorney.
A devoted daughter and sister in a tight-knit family. She came from a very humble beginning. She is a successful recording artist now, but she was born in poverty in New York City's Washington Heights. She worked very hard to get where she is, and in 2015 she joined the cast of a reality show called Love and Hip Hop New York, and from there she all of a sudden got all these followers, and that ended up with her becoming a Grammy Award-winning, critically acclaimed recording artist.
Can't hear too good, so I'm not saying much, but opening statements, basically the opportunity to frame the evidence for both sides. Can't argue the case yet. You're just saying what you expect the evidence is going to show. So defense lawyer telling a little bit about Cardi, who she is, and what he expects the evidence is going to be, and showing who she is as a person.
A friend, or she asked someone to recommend a gynecologist. She wanted to just check. And so she made an appointment, or an appointment was made for her, to see a gynecologist at a medical building in Beverly Hills. They took special steps to make sure this was private. The appointment was on a Saturday afternoon. The doctor, the gynecologist, had arranged for his staff to leave early. Her normal security person did not join her, because what could happen? She was going into he stayed in the car, she was going into a doctor's office, so what could possibly happen? And what happened was plaintiff. The evidence will show that plaintiff had her phone to her ear when the elevator opened, as Cardi was trying to make her way to her doctor's office. She was a patient. And the plaintiff stated out loud, "Wow, that was Cardi B." Cardi turned around and saw the plaintiff holding up her phone, filming or photographing her. And Cardi said, "Why are you doing that? Why do you think you can photograph me?" Just steps away from my doctor's office, and
there we go.
The evidence will show that plaintiff's response was a belligerent "because I can." Now, you will hear evidence that plaintiff continued to follow Cardi as Cardi tried to get to her doctor's office. Evidence that plaintiff continued to yell at Cardi. That when people from the doctor's office came out and told plaintiffs to stop, saying, "You're a security guard, what are you doing?" That plaintiff continued. And when someone intervened and got between them, plaintiff started taking swings at Cardi B. As Cardi B backed up and backed up, Cardi B was facing someone, with all respect, who testified and admitted that she was 240, 250 pounds, wearing black military boots, hovering over Cardi, yelling and screaming at her and taking swings at her, trying to get to her beyond the person who was trying to intervene, trying to calm things down. Now, I don't take any pleasure in saying this, but there will be evidence that it was plaintiff who yelled, "I will fuck your shit up." That's when someone intervened and dragged plaintiff to an elevator and said, "You have to leave. You have to leave." You will hear Cardi's testimony that she both feared for her unborn baby, this was her first pregnancy, and a very large woman was advancing towards her, and she was utterly confused that a security guard would be her attacker. Importantly, plaintiff has repeatedly changed her story over the last 7 years. You will hear evidence that, under oath, she stated in what is called discovery, Cardi beat her about the head and body. Under oath, she said that. You will hear evidence that plaintiff stated, Cardi scratched plaintiff's nose. You will hear evidence that the story then changed, that Cardi instead scratched plaintiff's cheek, and you will hear evidence that plaintiff also said Cardi never touched her. That is the evidence that you will hear. And to put it mildly, we expect the evidence will establish that plaintiff is not telling the truth. Now, there's been this allegation that plaintiff...
And that's all you can really do as a defense in this case, is either try and impeach the credibility of the plaintiff, of basically poke holes in her story, show she's being inconsistent, or at the very least to show that this was basically, if there was any sort of altercation, it was a mutual altercation, if not one that was instigated by the other side. So that's all he's doing is framing basically their side of the story. That's all the opening statements are really used for.
that Cardi got plaintiff fired. But we expect... Your Honor, we'll discuss this issue.
Assisting police was wrong.
Oh.
The claim was wrong.
Oh. I didn't know that.
You see all the heads going back and forth. Yeah, it's rare to get an objection during an opening statement, but certainly you can go across the line, go too far with what you're saying. In an opening statement, you're supposed to only frame what you expect the evidence to say. If you cross the line into now you're arguing, then certainly that's grounds for objection. And you hear the judge, he sustained the objection, so he agreed with the plaintiff's counsel that Cardi's lawyers were doing too much there, arguing. But it's funny, all of them whipping their heads back and forth all in sync. It's like, whoa, wait a second. But it got sustained, so yeah, they were in the wrong for that.
So there's no appointment plan? Okay. You've been very patient. The case just got smaller, but we still have a lot of evidence to put on, and I thank you for your patience, and thank you for keeping an open mind and waiting until you hear both sides. Thank you.
All right, thank you, counsel. We're going to begin with the presentation of evidence at this point in time. Does plaintiff have a witness to call?
Yes, Your Honor. Plaintiff calls Monio. This stands on first witness.
Thank you.
Yeah, no, you definitely can't object to an opening. It's rare. And that's why the lawyer kind of stopped at that point. He's like, ooh, I don't want to get too deep into this. But it's also forecasting some of the contentiousness that goes between these parties. In the clips I've seen, there's been a lot of objections. All right, first witness up, the plaintiff, the one who's accusing Cardi of assaulting her. So makes sense. This is who you would start with. As the plaintiff bringing the case, go up there and tell your story of what happened.
Your Honor. Good afternoon, Ms. Thomas. For the record, how old are you?
32.
And on the date of February 24th, 2018, what were you doing?
I was at work on duty as a security guard.
Where were you?
The address of the building was 8920 Wilshire Boulevard.
And for how long had you been working as a security guard as of 2018?
For 4 years.
And what did it take to become a licensed security guard?
You have to get fingerprinted and it's sent to the state of California for approval.
And do you have any criminal record?
No.
Could you become a security guard if you have a criminal record?
No.
Pretty basic.
Have you ever assaulted and battered anybody in your lifetime?
No.
Were you using your telephone to take photographs of the defendant when you saw her exit the elevator?
No.
So if you just tell us in your own words, when you got to the 5th floor, you were doing your rounds, you saw Cardi B, what did you say?
I said something along the lines of, that looks like Cardi B, or wow, that's Cardi B.
Were you talking to anybody at that time?
No.
For sure.
Yes.
Did you?
Yeah.
Were you?
Interesting. They're jumping right into it. I would be asking more like set the scene, build the day. You want the jury to really feel like they're in the presence of what's happening.
And the first thing out of her mouth was, excuse my language, was, why the fuck are you telling people that you see me? At this time, I tried to calm her down and assure her that I didn't tell anyone that I seen her, and she was extremely upset.
And what did she tell you after that?
Then, excuse my language again, but she said, yes, the fuck you did, and then she put her finger in my face.
When she put her finger in your face, did she have long fingernails?
She did.
And approximately how long were her fingernails on the date when she put them in your face?
About 2 to 3 inches long.
When you have seen different pictures and videos of Cardi B, you notice that she has long fingernails in those videos and photographs.
Yes.
When you saw her today, did you notice that her fingernails were very short?
Yes.
Does she usually wear them that short? Objection?
Yeah, objection to that.
Also, class conviction sustained.
Have you seen?
Yeah.
We'll strike that.
Yeah, so objection. What does she usually do? It's to ask questions. Basically, when you're calling a witness to testify, witness is limited to their five senses of what they saw, heard, smelled, felt, or I guess tasted, if you want to include all 5 sentences. But it's really what did you see, what did you hear, what did you experience? And asking someone, okay, what is the general rule? What usually happens? Like, okay, does she usually have nails? Yeah, you're kind of getting beyond the what did you see, what did you witness? To ask someone like how does something usually go? In most contexts, that's going to require them being qualified as an expert to determine, to give that opinion, because what is something usually? That's an opinion at that point of, oh, my opinion, something is usually X. So, yeah, proper objection, and it was sustained, so.
For how long? Were you a fan of Cardi B before this incident?
I was.
What kind of fan were you?
I enjoyed her music. I was interested in going to a concert. I didn't have any problem with her.
Did you ever go to see her in concert?
I had tickets to go to see her, but I never went after this incident.
When were you supposed to go see her in concert?
I'm not sure of the date. It was sometime in 2018.
And you're very close with your grandmother, Diane Schmidt, is that correct?
Correct.
How old is your grandmother?
She's 79.
Does she have information about the sense of objection? Assistant question, explanation.
Okay, if there's one.
That's what I don't understand. Why are we getting so? It feels like we're flying too fast, and I know I got the speed at faster speed, but like, this is all these questions. This would all be in the foundation you're trying to lay out, and like, who is this person? Who are you? What do you do for work? Where are you from? What's your family situation? Like, as a plaintiff, you're trying to get the jury to know your client, to really put themselves in the shoes of your client and feel like they get to know them well. It feels like we're just flying through. Like, we immediately jumped into, well, were you in the elevator? What happened in the elevator? I was there and I saw Cardi B, and then she put her finger in my face. And it's like, well, do you know your grandmother? Do you know her well? It's like, let's take this one step at a time. Let's do the get to know you first. Think of it like dating, right? You're trying to get to know this person. Yeah, because you ultimately want the jury to empathize with their position. And yeah, very scattershot so far for the plaintiff.
Did you show your grandmother the scar on your left cheek after February 24th,
Objection.
2018?
Could you repeat the question, please?
I overruled
Did you show
it.
the cut on your left cheek
Argumentative
after
and
February
foundation.
24th, 2018 to your grandmother, Diane Schmidt?
Have we seen
Yes.
a picture of this cut?
And what year were you born?
1992.
And how many brothers and sisters do you have?
I'm the oldest of 5.
Y'all see what I mean? It's like we're going from what happened on the day. We got like 2 minutes of what happened on the day. Now to, do you have Cardi B tickets? To, are you friends with your grandma? And now it's going to the year you're born. It's like, did they not have a plan going in? Usually when you've got a line of questioning, even if you don't want to script out word for word what your line of questioning is going to be, you have a general idea of like your bullet points of what you're going to be asking. God, yeah, I don't know what these lawyers are doing right now.
And your grandmother has seen you regularly from birth up to the present time?
Yes.
And what about your mother? Did you live with your mother up until a certain point?
Until the age 19.
Yeah, he's all over the place. I don't understand.
Let me take you a little bit back to this. So, when you were at the building and Cardi B exited the elevator on February 24, 2018, what were the words that she used that were so hurtful?
She used a lot of words, and again, excuse my language, but she was like, fuck you, you fat ass bitch, that's why I'm gonna beat your ass, I'm gonna get you fired, nigga this, nigga that, bitch ass nigga, that's why you do security, ah, that's why you do security, ah, she was sticking her tongue out, she was flailing her arms up and down, she was jumping up and down, body shaming me, I mean.
All right, let's be honest.
Racial slurs, just a lot.
That sounds like Cardi.
Did she spit on you?
She did.
Did her spit actually land on your body?
It did.
Why did you exit the elevator to speak with her after she said what she said?
I wanted to clarify the misunderstanding.
Did you also want her to leave because she was causing a disturbance?
At that time, she was causing a disturbance. She was yelling and screaming, and I didn't want her to leave.
And as a security guard, were you working there as an extension of the owner to be able to make that kind of call, whether somebody should be told to leave because they're causing a disturbance?
Instruction leading my foundation helps legal for this.
Yeah.
Could you repeat the question, please?
No, it got sustained. Don't answer it.
Did the landlord hire you as a security guard to protect its building?
Yes.
Overruled.
And did
Yeah,
you
at
do
that point.
Yes.
For how long?
But again,
For-
once again, these are all questions that you want to get out the gate right in the beginning of like lay all this foundation out of who this person is, so that way when you actually get to the meat of the story of what actually happened, you're bypassing all these objections for foundation.
About 4 years.
During those 4 years, did you ever have a problem with anybody else?
Never.
Not one time.
Not as far as I can remember, no. Not a perfect employee, but a good employee.
Did the defendant take a swing at you?
She did.
When she took a swing at you, it didn't hit your body, correct?
No.
Did the defendant use her fingernails to cut your face?
She did.
As a result of the cut to your face, did you have to see 2 different plastic surgeons?
Yes,
Did you undergo plastic surgery?
I did.
Your Honor, if I may show exhibit number 7.
When I took the photograph, you never disclosed it.
22 photographs that we discussed already.
I'm going to let him show the photographs.
For the record.
What's that?
I'm sorry, for the record,
Oh, can you just identify by number?
Yes, Your Honor. Would it be okay to get one of those photos?
Sounds like the defense is saying they have not received these photographs yet, which general rule, we don't like trial by ambush, so you're supposed to disclose these things ahead of time.
7-001.
Understanding you're objecting to their admission, do you want to lay foundation, or are we going to stipulate foundation?
well, that's right, right?
You want to
I said you're
stipulate?
asking him to lay foundation.
Do you want to lay foundation, or you stipulate, sorry?
No, no,
Okay. Then why don't you show the photograph to your client first to identify what it is?
Yes, sir. If you can look into that notebook on your right, there'll be a number 7.
Certainly there's a kind of a strategic point there of, okay, do you want to object for lack of foundation?
At some point recently, did you?
Yeah, do you want to object for lack of foundation? And Cardi's lawyer is like, yeah, I could at this point, but you know the witness list, you know the plastic surgeon is probably going to testify, at least based on the witness list. And so if you're talking about work that was done by the plastic surgeon, all you're doing here is getting in photos to establish the photos that she took. So laying down foundation, getting proper authentication, asking her, do you recognize these photos? Yes. How do you recognize them? I took them. What are they showing? They show me. When did you take them? Give an approximate date. What do you use? I use my phone. Stuff like that. These are all foundation questions. And then once foundation's laid, you move to admit it as an exhibit. That's when the defense has an opportunity to either object or not object. Either way, judge makes a ruling on whether or not the exhibit comes in. Usually photos, it's a pretty low bar to get them in. It's pretty easy to establish foundation for what a photo is, and that it purports to represent, or that it represents what it purports to represent, basically. So
You go to the building.
yeah, they got to get their audio
Yeah,
together
company,
though. We're only getting audio out of the left right now from the screen.
People from my office to take photographs of the incident.
Yes.
And the purpose of taking the photographs were to show where the incident occurred and give the jury understanding of what kind of building we're dealing with.
Yes.
And you feel it's important that they see that?
Absolutely.
Your Honor, may I publish that? 7-001?
You only had her authenticate number of the first page, and just want to have her thumb through it.
Sure.
Verify the photographs you took in the page.
Yes, Your Honor, I will do so. If you can look at 7-001 through 7-022, if you can look at all those photographs. Are those photographs of the building where you worked on February 24th, 2018?
Yes.
And if you look towards the end, 7-022, is that the area where the incident took place?
One second.
There we go. Thank you, audio guy.
Yes.
Can I show them too?
Yeah, just identify them as you published.
There you go.
Now each courtroom does it differently. If they're going to show the exhibits through like a projector maybe, or just passing out physical copies to the jury for them to look at like in their hands.
Okay, I'm just going to show exhibit 7-001.
Looks like they're going to project them on a screen. I don't know if we're going to see it, but she's obviously looking at something.
Ms. Ellis, is this the photograph that we discussed, which is the outside of the building where you worked at 8920 Wilshire Boulevard in Beverly Hills?
Yes.
Okay.
And the fact that they're being published means they were admitted by the judge. They're admitted as exhibits. Sounds like Exhibit 7 contains like 20-something photographs in it. So just showing. Now this is the thing you want to lead off with. I don't know why it took them 20 minutes to get to this part, but these are the kind of things you want to set the stage for your jury. Like, think of it like a play. Or a movie. We're telling a story here. We got to meet our characters. We got to establish our setting. We got to establish our tone, our themes, our relationships to each other. Like, this is all like stuff you lead off with. I don't know why we spent 15 minutes going through ping-ponging from random different points, but I don't know. Then again, these are plaintiff's lawyers. Plaintiff's lawyers usually work, in a case like this, they work on contingency fee, meaning they get a cut of whatever the award is. So you can be a crappy plaintiff's lawyer and someone will hire you because they're not paying you any money unless you win. Defense lawyers, typically, they charge hourly. And that's where if you're like someone like Cardi B, she's going to have really good lawyers. We can know that. So I can make an educated guess that Cardi's lawyers are very good. This girl, Imani Ellis, her lawyers, no idea how good they are. So far, not impressed at all, though.
7-002, is this a closer picture of the same building?
Correct.
And this is a 6-story building in the city of Beverly Hills. It's an older building, correct?
Correct.
And then 7-003, we're getting closer to the front?
Correct.
7-004, is that the front entrance of the building where you work?
Yes.
Okay. 7-005, another photograph of the same front, closer up?
Yes.
Sucks not being able to see it, but
You see that photograph?
I think we can get a good mental image. We're
Building where you work.
looking at a doctor's office right now. Oh, cameraman?
Was that security booth there when you worked there? Do you remember?
It was.
All right,
Did you sit behind
cameraman
that
coming in
security booth?
I
clutch.
did.
And on the date of the incident, were you wearing your uniform?
Yes.
7-007 is a photograph of that booth where you sit. 7-008, was that sign there on the date when you worked there?
Yes.
7-009, these are the elevators that guests and visitors of the building would take to get upstairs, is that correct?
Yes.
And on the day of the incident, do you remember if you took the elevator to get to the 5th floor or maybe took the stairs? Do you remember?
I'm not sure.
All right, if I can take, we're going to skip.
I mean, I'm definitely thinking of questions. What I'd be cross-examining her on, and mostly right now is what were you doing up and around if you had a station that was that podium that was just shown. I know she mentioned briefly like she has to do these rounds, but I'd definitely be diving into, is that a real thing? Is that a real policy? What's expected of the rounds? Are you supposed to take the elevators to go up? Are you supposed to take the stairs to walk around? Because if you're doing rounds, presumably you'd want to be checking all the little nooks and crannies. So already her story's getting a little iffy on, okay, what were you really doing?
It was Saturday, correct?
Yes.
Was it this way with garbage all around there or not?
Not at that time, no.
7012 and 7013 and 7014 and 7015 are photographs of the hallway leading up to the elevator bay, correct?
Yes.
And did Miss Cardi B walk down the hallway after she spoke with you and came back, or did everything happen right at the elevator bay?
She did. She came out and looked around, and then when she heard what I said, she turned back around to approach me.
So if we could go to 7-021.
Yeah.
This is where
Basically,
the
a job
entire
profile, or
incident
even
occurred.
a better way of saying it is is like a dating profile, like here, like get to know this eligible bachelor or bachelorette, like it's like, yeah, get to know them, who they are, what they do, like really put the jury in the shoes of your plaintiff, because at the end of the day, you're asking the jury to award a bunch of money based on damages to the plaintiff. What's the best way to accomplish that? Get the jury to feel like they themselves are in the shoes of the plaintiff and have been damaged similarly.
Face or any injury sustained after the assault and battery.
Objection, last foundation argument.
Can you repeat the question?
Why did you not take photographs of the scar after the incident?
I was upset. There was a lot going on. I'm not sure.
And you were not intending to sue, is that correct?
No.
Yeah, character building,
Were you
exactly.
intending to sue Cardi B at that moment when the incident occurred?
No, I was not.
In addition to being a security guard, did you have an interest in criminal justice?
Yes.
What were the classes that you took or were going to take?
This is all stuff I'd be leading with. I don't know
I have a
why.
bachelor's degree in criminal justice administration.
I don't know why we're just getting to this 30 minutes in, man.
I chose a different career field.
What is your current career at this time?
I work in social services.
What do you do? Who do you work with?
I work with low-income families to access resources.
Did Ms. Cardi B, after this incident, post different things about you to her fans?
She did.
And how many different instances?
Probably about 2.
And did you do the same thing back to her?
Never.
After the incident, did you seek medical treatment from a psychologist, Nicole McKenzie?
Yes.
And that was approximately 2 months after the incident?
Correct.
What did Dr. McKenzie do for you?
She provided therapy, counseling therapy.
Was it helpful?
I really was at the time.
Before the incident, did you ever have any type of psychological or psychiatric medical treatment?
Can I answer it? Okay. Something happened with my sister and a neighbor. My family was given therapy on behalf of that. That was all my fault.
So they're moving, or part of their damages here, they're trying to say that she suffered emotional distress, and so one of the way you prove that is, okay, did you have to do therapy, and how much did that cost, and basically proving that there was real emotional distress, but also that so there was the cost of the therapy, but also just the intangible cost of, I'm just so traumatized by the incident. Now we're blacked out again, but. Yeah, so I would expect the therapist to probably come in and testify to the extent of the emotional trauma that the plaintiff has suffered.
Sustained. Please disregard the prior answer.
Did you go to Nicole McKenzie because you were assaulted and battered on February 24th of 2018 by Cardi B? Objection.
Over.
Answer. Yes.
Did you go there for any other reason?
No.
And around that time, did you also seek medical treatment from Dr. John Scher?
I did.
And he's a cosmetic plastic surgeon?
He was, yes.
Is it your understanding that he died in 2021?
Yes.
And when you saw him, did he advise you that you needed to wait at least 1 year to determine if the cut became a scar? Objection.
Hearsay and me.
All right, really interesting issue here. The doctor she went to apparently has passed away, and now they're trying to ask her, what did your doctor say to you? Now, that is hearsay, and it was just objected to for hearsay. And I paused it before the judge ruled just to give the brief snapshot. Hearsay, right, is an out-of-court statement offered for the truth of the matter asserted. Basically, any statement that you heard somebody else say, not something you said yourself. So what the doctor said is hearsay here. However, there's a bunch of exceptions to hearsay, some related to medical statements made for medical diagnosis, also statements made under a present sense impression. There's also different exceptions that apply based on whether the witness is unavailable, for example, like being not alive anymore. So this is definitely hearsay. However, I can see the judge relaxing it because the doctor is no longer alive. It's not like they can just call him to testify anyway. So the judge, I can see him overruling the objection and letting her get into that.
I want you to rephrase the question.
Did Dr. Scher ask you to return approximately 1 year after he saw you for the first time?
He did.
Why did he ask you to wait 1 year?
Yeah, so objection got overruled. Judge is letting it in.
Close for speculation.
Do you know why he asked you to wait for a whole year before seeking medical treatment?
Objection, last foundation.
He said he was going to treat it prematurely and for me to come back.
Did the scar become a keloid?
It made a scar, yes.
Do you know if it's called a keloid or you're not sure?
I'm not sure if it's on keloid.
Before the incident of February 24th, 2018, did you have any scars to your left cheek?
Never.
Did you have any scars anywhere in the face?
Never.
At some point, well, straight. Do you remember the pandemic in April of 2020?
I do.
You remember that there was a period of time where elective medical treatment was not allowed?
Yes.
What about the cost of the treatment? Could you afford to pay $15,000, $20,000 to get plastic surgery to your face?
No.
Did Dr. Mulliken agree to treat you on a lien basis?
He did.
And when you got medical treatment on a lien basis, is it your understanding that regardless of the outcome of the case, you still owe Dr. Mulliken the fees for the treatment that he did? Is that your understanding?
Yes.
Did you also see the pain management doctor for one visit?
I did.
Now, there still would be ways around it if the doctor's not available. You can have maybe someone from his office come in and testify to the work that was done, or have another doctor come in and review the work that was done and give their own opinion on it. There's ways you can still establish the extent of the plastic surgery that may have been required here.
Second of 23.
Objection. It's a violation of the order granting the motion to eliminate.
I'm sorry, can you repeat the question?
Did you seek treatment from psychologists, including Alex Avila and other psychologists from October 8th, 22 through July 2nd of 23?
Same objection.
Correct, yes.
And for that psychological treatment, did Dr. Avila's office agree to treat you on a lien basis?
They did, yes.
For Nicole McKenzie, did you
Cardi's looking a little stressed right now.
$5,087 for office for medical treatment that you received related to this incident?
Objection. Thinking. Next foundation.
Sustained.
Is it your understanding that your total medical bills related to this incident are $36,000?
You need to start with the foundation. You need to establish what she knows and how she doesn't.
Thank you. Did you receive medical bills at your home from these different medical providers?
I'm not sure.
Yeah, pics would help. I imagine that's something they'll be getting into. But once again, it's one of those things where it's like, why are you not laying this foundation out already? And then get all your exhibits in, and then from there you tell the story in just one cohesive piece where you can literally be illustrating the story like a picture book. You're holding up pictures to narrate and show the different things as they're happening. Something that should have already been done. At least something I already would have done.
Sustained.
I do, yes.
So, the objection sustained.
I'm sorry.
Sustained.
The judge says sustained that you don't answer.
I apologize.
How often, since this incident of February 24th of 2018, how often do you see your grandmother, Diane Schmidt?
Objection. Otherwise.
No, that's relevant.
And where does she live?
Especially if she's on the witness list to testify.
And she's here today to testify on your behalf?
She is.
Do you know how old your grandmother is?
79.
Do you have respect for authority?
Yes.
Yeah, objection. Yeah, what
Where
is
does your
that?
grandmother live?
Las Vegas?
Do you ever visit your grandmother in Las Vegas?
Yes.
And for what reason did you visit Las Vegas to visit your grandmother?
To check on her, she's a senior.
Crazy. Her grandma's a senior in college? Wow.
Do you take any medication or drugs?
No.
Do you drink alcohol regularly?
No.
Once again, these are all stuff I'd be leading with. This is all part of our, remember, it's all part of our dating profile. We're getting to know our victim here. We're
Can you
getting
tell
to
us a
know
little bit
them.
about what your expectations are when you work security?
But
at
you
that
lead
building?
with that. You don't do that
February 24th of
35 minutes in.
Are you asking me what were my duties today?
What were your expectations? What was your expectation from visitors or guests who were coming to that building on that day?
Sustained.
Yeah, objection.
When you worked security on February 24th of 2018, did the owner hire you to do security for them?
Yes.
And why did they hire you?
Objection, speculation.
Next foundation.
Sustained.
Sustained. Boom. Look, I could be doing this.
And after this incident, you decided to discontinue working as a security guard. We're not blaming it on the incident, but we're saying that, I want to be clear that after this incident, you have decided that you're no longer going to work as a security guard, correct?
Yes.
And before the incident happened, did you have that intention, or did that intention come about after the incident occurred?
Objection. Not valid.
It came after the incident. I had plans of promoting, moving up, definitely staying at that job.
Did you, well, strike that. Did you ever want to become a police officer?
I did.
Do you still want to become a police officer?
No.
And why is that?
I was deeply traumatized about what happened.
Deeply traumatized.
Can you tell me a little bit more about your trauma that you suffered from this incident?
Yes. I deal with anxiety, deal with depression. I have post-traumatic stress. I have a scar on my face. I deal with insomnia. Things like that.
Do you believe that the incident, are you single at this time?
I am.
Were you single at the time of the incident?
I'm not sure.
Do you believe that this incident has an effect on your future ability to have a partner?
Objection, last foundation, false arrest, testimony.
Assistant.
Yeah, that's a weird question. Although arguably relevant, if you're talking about how she's been traumatized by this incident, I think that's actually a relevant question.
Do you expect Cardi B to pay for your medical bills?
Yes.
Assistant. Son.
Aside from calling you the N-word, spitting at you, taking a swing at you, cutting your face with her fingernails, is there anything else that she did on February 24, 2018 to you?
I mean, the whole incident was super traumatizing for me. She did a lot that day.
Did she ever apologize for what you did?
Never.
Did you want her to apologize?
Of course.
Yeah, he tried to ask if this affected her relationship, but they got objected to and got sustained. I actually think that's a relevant question. If you're trying to assess the extent of the damages, especially the emotional trauma and distress that occurred, then I think the impact on your personal relationships, I think that's certainly relevant, especially considering I don't know much about this trial. I do know that I think her mom and her grandma both testify in it. So it's like, obviously you're going to allow people with personal relationships to her to testify. Yeah, that's probably an objection. If I'm the judge, I'm probably overruling that objection to let her talk about how her relationships have been affected.
Thank you. Thank you, Your Honor.
Cross again?
Here we go. All right, cross-exam is always where the real nuts and bolts come out. It's the most difficult part of trial lawyering. It's the toughest part to get through as a witness because you are on the hot seat and you are getting grilled. So, and Cardi B, we got to expect she's got some good lawyers. So I'm expecting a lot out of this cross-exam here.
And it's okay, I'll use the podium. What's the slide address? Good afternoon, Ms. Ellis. Your lawyer showed you photos of the building that you were working on at as a security guard in February 2018. Do you know the name of the building?
I don't know the name.
Was it Beverly Hills Medical Center?
It could have been, yes.
Yeah, it was a medical facility, right?
Yes.
And the incident that you claim happened that day happened at approximately 1:30 p.m.?
Approximately, yes.
Talks a little fast.
And you knew at the time, when you saw Cardi B, that she was going to a medical appointment, correct?
I didn't know where she was going, but she was at the building.
And you understood that she was going to a medical appointment, right?
She was going to an appointment, yes.
And it was a medical building, right?
Yes.
Your deposition was taken and you said that you testified under oath in your deposition. Let me ask, do you remember your deposition was taken in this action?
Yes.
Do you remember taking an oath at the deposition to tell the truth?
Yes.
And that under the same penalties of perjury that apply in this courtroom, for example, correct?
Yes.
And you
Classic cross-exam. Usually, especially a case like this, you're going to have deposition testimony of all the witnesses, so you have an idea of what they're going to testify to at trial. And really, it's really as simple as you get super familiar, super well acquainted with their deposition testimony, and that way when they come to court and they testify, if they say anything inconsistent between their deposition and their court testimony, you can point that out to them and ask them basically, you can even frame it like, so were you lying then or are you lying now? And just try and get them to trip up. And even if something like trivial, like kind of what's happened so far, it's like, well, you said you knew it was a medical appointment, but now you're saying you don't. So which one is it? You're lying then or you're lying now?
testified that you understood when you saw Cardi B that she was going to a medical appointment, right?
Yes.
Now,
Trying to point out inconsistencies
after
to the
this
jury.
incident, you talked to your supervisor at Allied, right?
Yes.
And she told you to submit a incident report, correct?
Yes.
And you emailed an incident report to your supervisor 2 days later, right?
I don't know about 2 days, but I sent it to her, yes.
Yes. And it was by email.
I'm not sure how she received it.
Your Honor, if we may, I'd like to show the witness the incident report that she did not produce in discovery.
To refresh your recollection.
I would object to that based on authenticity is not heard of.
Authenticity. Hold on. Okay. Basically, it sounds like he's saying, I want to show the incident report that she submitted to her superior. I want to show this to her to refresh her recollection, to get her to jog her memory, to be like, hey, you remember this, right? And he made a comment there that, Your Honor, I'd like to show the incident report that was not disclosed in discovery, meaning the plaintiffs never gave it to us. Hello, Gen Z. There isn't any camera footage of any of this. I guess we'll see later, getting into the trial. I truly don't know. I would imagine there would be. We're talking about a doctor's office. These are secure facilities, have high security. I mean, they got security employees that supposedly, apparently here, are tasked with walking around keeping tabs around the building. And so I would expect there to be camera footage, but I guess we'll see as it comes out. But but what he's saying here is, I was never given this in discovery. I'd like to show it to her. And now the defense or the plaintiff is objecting and saying, oh, this lacks authentication. It's like, bro, the only reason he's got to put this in is because you never gave it to him. And now he's got to try and put it in himself. And so it's kind of like this is something he is obligated to have disclosed, or at least should have disclosed in this situation. Certainly relevant. And especially if there was a request for documents in discovery. It should have been disclosed, and it wasn't, and so now he's got to do it himself, and now the guy's objecting to it, but he's just got no grounds to object, so this should absolutely be shown to her.
This is a document that we got from Allied pursuant to a trial subpoena.
Same thing happened with Tori. Yep, exactly right.
And it's not in the book, so let me provide a copy. Should I hand it to the clerk?
You can push.
Oh, thank you, Ron. Just make sure. Here we go. Does that refresh your memory that you sent an email to your supervisor on February 26, 2018?
Okay.
Do you recall that now?
I don't, but I'm looking at what you gave me.
And that's your email address, right?
Yes.
And it's addressed to your supervisor, Jasmine?
Yes.
I get you feel like you're getting grilled. You don't want to give him anything, but just bite the bullet. Just be like, okay, yes, sure, this looks like me. If you say it's me, then I won't dispute it.
224-18 incident report. Do you see that?
Okay. I see it, yes.
Now, before we talk more about that incident report, do you remember receiving in this case discovery requests that you had to verify under oath, where people asked you questions?
Discovery requests is what I just mentioned.
I'm not sure.
Let's see if we can refresh your recollection.
Yeah, this is always a challenge. You're going to have witnesses on cross-exam that are going to hit you with a lot of I don't recalls, I'm not sures. And you're going to have to sometimes walk them, hold this stuff right up to their face and show them.
Your Honor, to explain counsel that it's plaintiff's response and objection to defendant Cardi B's demand for production of documents, set 2. And, yeah, sure. Thank you. Look to the last 2 pages. Is that a verification by you, signed by you, under oath, that the statements in the response, are true and correct?
I'm sorry, were you asking me?
Is that your signature on the last page?
Yes.
And you verified that, you signed stating that on penalty of perjury, the statements in the document are true, correct?
Yes.
Okay.
All right, this is good setup. You got to think about basically what he's doing here, and
I'm not sure.
Well, please look at it.
Yeah, what he's doing here. Think of it
Please
like.
look at pages.
I'll pause it. Think of it like a setup and a takedown. Okay, you're when you're impeaching a witness, basically impeaching their credibility. You do it through setup and takedown. If you just go straight for the takedown, it's not going to hit as hard. If you prop them up first and set them up by saying, hey, you signed this piece of paper saying you swore to this statement, right? You swore to this fact, right? Yeah, that is my signature. I did swear to that. Okay. And then you hit it. That's the setup. Now you hit him with the takedown of like, isn't it actually this other fact is true and not the one you swore to? And then you put them in such a bind where if they deny this other fact as being true, even though it's like eminently just a correct, empirically correct fact, now it makes them look stupid because they're like, yeah, is your name Amani Ellis? No. Okay, then now they look stupid because they're denying something that's just so obviously true. So it's good. We're watching it happen in real time. Set up, takedown. I want y'all to remember that on cross exams.
5 and 6, the plaintiff has no emails related to this lawsuit.
Are you asking me about this email on the paper?
I'm asking you about the response. You made a discovery in this case, stating that under oath you have no emails that relate to this incident.
Well, that's correct. I don't have access to this email anymore.
Okay. So okay. Let's go back.
So just so everyone gets that, Cardi's team, they made a request for documents, and they asked her, please turn over any emails you have related to this incident. She submitted a sworn statement back saying, I don't have any emails, and she swore to that under oath in the form of an affidavit. And now, Cardi's team came to find that actually there is an email that she submitted to her supervisor that was related to this incident. Now, she's trying to squirm away from it by saying, well, I don't have access to that email at this time, so when you ask me the question, do I have any emails? The technical correct answer is no, I don't have any emails, but the jury is going to look at that and be like, oh, that's pretty slimy, that's pretty shady. And also, because this is going to be an eminently reliable document of the incident report for what happened at the time, because whatever she said at the time, I'm imagining is probably not going to be very beneficial to her testimony today, which is why Cardi's team really wants to get it in. That's why they're leading with it in the cross-exam.
Actually, we have one other response, another sworn response. Your Honor, I would like to show the witness plaintiff's responses to defendant Cardi B's special interrogatories, which, rather than asking for documents, ask for information. May I approach?
Go ahead.
What is the date of the document?
It was served on January 3rd, 20.
So yeah, you've got request for documents, which is what they did, requested for emails. You've got to hand over the documents. You can do as many of those as you want. What he just gave her now is looks like interrogatories. Interrogatory is a fancy way for saying questions, and you have the ability to ask questions through discovery that the other side has to answer. Now, you usually get a limited amount. I know in North Carolina you get a limited amount. That's where I practice. But interrogatories are going to be your like, please describe XYZ instead of just hey, please give me this document. You're actually asking them some open-ended questions because you want to get their answers to. Because once you get to court, you never want to get to a position in court where you're asking a question you don't already know the answer to. Before court, when you're talking about depositions, you're talking about interrogatories, that's the perfect time to ask questions you don't know the answer to, because that's what you're trying to do. You're trying to find the facts to be able to be the most prepared for court.
And that's your signature at the last page, verifying under oath that the statements in the document are true and correct?
It's my signature, yes.
Okay. And you understood that you were verifying under oath that the statements in that document were correct?
Yes.
Okay. And in that document as well, you said you had no emails related to this incident, this lawsuit, right?
I'm not sure if I said that in this document, but...
Could you please look at pages 4 to 5? In fact, you say it 5 times. And if memory serves, it's in bold.
If memory serves, it's in bold.
Okay.
All she could say
And
is
you
okay.
never produced the email that you sent to your supervisor on February 26th in 2018 in this lawsuit, did you?
I don't have access to that email, sir.
My question to you is, did you ever produce that email?
I'm not sure if I know what you're asking.
Did you ask, you had discovery obligations in this, did you ask Allied for a copy of the email that you are now testifying you couldn't access?
I wasn't in communication with Allied.
Okay, so...
that's not going to cut it. I mean, if they were able to get this email by asking Allied, I guess, which is a security company, if defense was able to get it just by asking, then her saying, well, I just wasn't in contact with them, that's not going to cut it. And now that gets us into discovery violations. When you violate your duties under discovery, the court can hold you in contempt, they can impose sanctions upon you, or they can let it slide and just let you cross-examine it in court and get basically just expose the inconsistencies in front of the jury, which is what he's doing here quite beautifully.
Let's talk about what you said on the email to your supervisor 2 days after the incident. If you look at page 1, it states that you were the daytime guard on duty at 8920 Wilshire Boulevard. You were on patrol, and I had, quote unquote, I had 2 cell phones, the work phone and also my personal phone. I had my cell phone to my ear. Do you see that language?
Okay.
Do you see the language?
I see it, yes.
And you wrote that 2 days after the incident?
I don't remember writing this, but if this is what you have, then...
Your Honor, I would ask that you read the whole sentence for completeness.
Well, I don't have it in front of me, so I don't know that, but to the extent.
Well, that's the portion I intend to read. I mean, he's welcome to read whatever he
I think
wants
that's
to
the
read.
plan, yeah.
Well, you're just reading half a sentence.
Sounds like, okay, they're going to quibble over the rule of completeness, saying, oh, well, if they can't just pick and choose. Well, from what I can tell, defense is not going to just pick and choose what this statement is. I think they want to get the whole thing in because it really shows that she's admitting basically that she had a phone out, and so whether or not it was actually recording anything, that's going to be for the jury to decide. But and this is really cutting hard against her credibility because she says, she's not willing to acknowledge it in her email. She's just kind of playing this game of like, well, I don't remember writing that. It's like, okay, it's under your email address. It's like the meme with Patrick in SpongeBob. It's like, is this your wallet? No. Okay. Is this your ID? Yep. Is this ID found in this wallet? Yep. And this wallet was one that I just picked up and I'm holding it out to you. Yep. So it must be your wallet. Sounds good to me. Okay, so take it. Well, that's not my wallet. Like, so this is your name on the email. Yep. And this was sent to your boss from the company you used to work for. Yep. And that's your company and the headline of the email. Yep. So this must be your email. Well, I don't know. Yeah, she's not coming across credible at all. But all right, Tara-isms in my mind. In this case, what's going to matter most then? Evidence or testimonials, especially since no video surfaced from that day, allegedly. Well, yeah, if there's no video, it's really going to come down to credibility. And this is what we talk about with the Tory Lanez case, where we have a little bit of video, but really not too much, especially, and we have none of the incident itself, of the shooting itself. So at the end, so that's why credibility is the most important issue. And Meg and her fans get really mad when you question Meg's credibility from that night. But I'm sorry, she's the star witness. Her credibility is squarely in the center of that case. And so it's going to be the same thing here. Is going to be the credibility of the witnesses that are testifying. And just so clear this up too, I see people say, well, there's no evidence in this case. Well, technically, verbal testimony is a form of evidence. So if you have someone testifying, then yes, there is evidence in the case, but maybe there's no hard evidence or no forensic evidence. But just as a FYI for all y'all out there, clearing up that misconception. Yeah.
It would be unfair for me.
Yes, Your Honor. Let me actually include the declaration that came with it. For that light. Sorry.
So yeah, we're still squarely in impeachment territory. Yeah, you can impeach a witness with their prior statements whenever you want. And that's what you're doing.
Talk about the first paragraph.
It does appear to be a narrative, so if you want to read everything in context, that would be great.
Should I read it, or are you asking me to read it?
No, go ahead.
Okay. And just that sentence, Your Honor?
Just read it. Whatever it is, make sure it's just in context.
Okay, thank you. Again, the context is that you state in this that you were a daytime guard on duty at 8920 Walker Boulevard. Per usual, I was conducting a routine patrol of the building premises, and as part of that patrol, I checked the rooftop, all tenants levels, and parking garages. At approximately 13:30 hours, and just to clarify, that is 1:30, correct?
Yes.
In this statement, I'm pausing it real quick just to, red flags, alarms blaring, everybody pay attention. This statement is going to be super important, I think, to this whole trial, because here we have a contemporaneous statement, meaning a statement that was given very close to the time of the incident, because we're talking about 2018. This is 7 years ago. Memories fail over time, and facts get misremembered. So a statement from the star key witness really at the time it happened, when she was not in the middle of suing for $24 million, that statement's probably going to be more reliable than the statement that she's making now, when she's trying to win $24 million. She's got 24 million reasons to talk about how horrible and evil Cardi B is now, but let's look back and look at how she was speaking back then and see if the vibes were a little bit different. So everyone pay real close attention to the statement as it's being read.
I was finishing a patrol on the 5th floor of the building. In my hand, I had 2 cell phones, the AUS work phone, and I also had my personal cell phone. I held my cell phone to my ear, checking my voicemail because my mother is recovering from cancer and is in chemotherapy, so sometimes I don't get the quick calls and have to check the voicemails. Do you remember that?
I'm reading it with you, yes.
And are you telling me you have no recollection of this 2-page email detailing the event that you've sued over?
I remember writing an incident report and sending it over.
Oh, so now she does remember. So remember, first she said, I don't remember this. I don't recall what this is. I don't know what this is. And he had to walk her through, hold her hand step by step, like, well, that's your name on it, right? And that's your email, right? That's your boss, right? And that's your company, right? And she was just saying, okay, I don't recall. But now she does recall. She did write an incident report. So, and remember too, her answer to the discovery question was, I don't have any emails related to this. And now she's admitting, actually, I do remember writing this. So we're catching her in just these little inconsistencies, and the goal is to just stack them up over time.
Well, you recall also that you produced in this case your T-Mobile cell phone records, correct?
Yes.
And if I could, I believe that's something we can display because it is an exhibit.
Can you share, Your Honor, may I ask if they can share the exhibit number, please?
So why don't we, just to move things along, why don't we take our afternoon break now? Ladies and gentlemen, we're going to take an afternoon break. Since we have a couple things to discuss, and I need to give the court reporter some time out. Why don't we resume back at 3:15? In the meantime, just want to discuss case of
Beauty of the playback. We can skip through the afternoon break. Here we go.
Using the right weight
Anyway,
matters.
while I get us back into the flow of things, yeah, I got a few more people in here, so hope y'all having a good. Sorry. Usually, okay, this is true. Usually, the lawyers will have an opportunity to be heard outside the presence of the jury before the lawyers get a break. So just because the court goes on break and the jurors get to go out doesn't mean the lawyers. And usually, we're working through the breaks anyway because we got stuff we need to catch up on. So.
I'm not exactly sure what has happened. Did we not exchange exhibits? Do we not have a joint trial record? What's going on here?
I apologize. This is what we have tried to convey. Since July, we've been trying to work with this gentleman to get his exhibits and to finish the joint exhibit list. We have filed a memorandum of declaration that shows me in August repeatedly asked.
Okay, let's fast forward.
We have not.
Maybe there's a lack of meeting different. Do you have all their documents yet?
At 8:45, he handed it to me.
Okay.
And we previously produced the documents and produced them as trial exhibits by service at 11:47 on Friday, which he disputes happened, but I haven't produced service.
Okay.
And if I make my
So he's just detailing now all the poor communication that the plaintiff's lawyer is having, up to and including Judge asked him, "Have you received all their documents?" And he says, the defense lawyer, Cardi's lawyer, says back, I was handed those documents at 8:47 this morning." So obviously the plaintiffs are playing fast and loose with their discovery obligations here, and I'm very curious to hear their response.
I'll do it like that.
Sure.
Your Honor, I just want to be clear that on Wednesday I was leaving my son in college and got a message from plaintiff's counsel that the court wanted us to make change to the documents. He did not respond to this. Peter said, "This is detailed, it's something you filed to the court. Letter after letter after letter, he did not respond to. He already filed his documents to the court on Tuesday when he's leaving me voicemail saying, the court is telling us we have to make changes to the documents and submit them. The documents that were filed were not filed by documents." He was leaving voicemail saying we have to get the documents out while he already filed the documents. Yeah, I just wanted you to know. Those are not our documents.
Exhibits. Do you have you got their exhibits this morning?
We got their exhibit book this morning.
Okay.
Mark.
Crazy.
Sorry, I'm trying to not trip over a wire.
Got the exhibits the day of trial.
Almost killed me. I think what I'm about to say is correct, but one of these lawyers will correct me if I'm wrong. We initially, before the final trial status conference, filed what we had and explained that we had not heard from counsel. Counsel, the court admonished everyone to cooperate. We identified 3 remaining open issues and repeatedly asked him to identify the documents. He has these exhibits, for his exhibits, he had these generic references to medical records, things like that. We asked him, and he asked us his authenticity, and we said, give us the documents so we know what we're stipulating to. We did not get a response to any of those questions. He then unilaterally, as we got closer to the, he unilaterally last week filed these trial documents, which we understood he was saying us to review, pursuant to what the board has said, and found out only on Saturday he didn't actually file them. Yesterday, we, to at least show our side of it, because he doesn't include everything that we put in, filed our own unjoint and jury instructions and everything. So it is extremely confusing, I understand that, but there is no agreed upon joint exhibit list, there is no agreed upon joint witness list. Our witness list, for example, includes Tierra Malcolm, his doesn't, things like that.
Okay. Do you have all their exhibits now?
Yes, sir. I'm not clear what he's talking about. The court's order says we're supposed to bring them 5 books today. I brought 5 exhibit books today. I gave him one, and I distributed it to the court. And he's giving me his book. So I don't know what he's talking about. But what I do notice is throughout this cross-examination, it's just springing on things. I don't know if it's for impeachment or not, but that's my concern. When I ask him, where is the exhibit book? He
So
can't.
and I think that was one of the points the court made earlier. I don't want interrogatories and RFPs to be exhibits because they're not.
They aren't included in the exhibit book.
And so I think your obligation is to specifically identify the caption and the date it was served. I think that's adequate to put the plaintiff's counsel on notice.
And that's what I did, and yes.
I know, but you have to ask. So
My apologies.
Okay.
My apologies. And this particular Allied document is a document that was produced from Allied's records, this email. We have an affidavit.
No, I don't have an issue with this.
Yeah, it sounds like there's this really bad communication between. Sorry, I've been trying to listen real close because it's a little hard to hear, but it's been real bad communication between the plaintiff and the defendant's lawyers. And what the judge is going to have to do is trying to look and see where the breakdowns are happening to see basically who to blame, who to hold it against. And from what it seems like the plaintiff's lawyer is being a lot more fast and loose with the discovery obligations and turning stuff in late. Like even acknowledged there, it's like the court order said for me to bring 5 copies of my exhibit book, and I brought it this morning. It's like the morning of the trial. Like this is stuff that's supposed to be settled already. and established beforehand. And now judge is getting a little bit on the defense, saying like, well, why are you bringing in interrogatories and requests for documents? Why are you trying to get those in? Because those are not exhibits. It's like, true, those are not. But my read on it was he wasn't using those as exhibits. He was using those to impeach the witness by saying, hey, you said this earlier, right? She's like, yeah. And now you're saying something different. Yeah, it's classic impeachment by inconsistent statements over time. So I don't know why the judge is really getting on the defense. Maybe he's trying to appear like he's trying to treat both sides fair. But to me, the plaintiff is a lot more bad faith as of right now, from what I can tell.
I think she sent it.
And I showed him as I was passing what the discovery response was, but I'll be specific without him asking.
So I need you all to work together a little bit more.
Yeah.
Yep.
Shouldn't be fighting against each other. That's your clients that you're trying to represent here.
Work together more, yep.
So we need to put our heads together. Do we have a final verdict form?
We did it. We filed one before and he approved it. Your Honor made one change to it, and I don't recall what it was because we had, I think there were a few words that were different than the approved form, and that was the final status conference. We also had a joint statement that Your Honor made that over there.
So and here's the issue, just to explain myself with respect to the extent that she treated with a doctor. She did treat with the doctor, so I'm not going to exclude that. If I excluded the doctor as a witness, that's a different story.
Well, the evidence is that if you're talking about Dr. Avila, he was not a trained physician.
He testified that he was. So.
Well, that's because he's trying to do an end run around the exclusion of Dr. Avila.
All right. Anything further?
Yes, Your Honor. In my defense, Your Honor, all of these things I disagree with. I'm not going to get into the details. All I can say is Dr. Avila did treat my client, and he signed the report in the bill, and that's why I asked her about it. So.
Okay.
And if I may, just because I know you've got a lot of cases, Dr. Avila was never identified as an expert. He then tried to replace Dr.
We've gone over this. Okay.
Yeah, it sounds like
Thank you.
Okay.
this has probably already been addressed at a pretrial conference as to the admissibility of this doctor as an expert. So in one sense, we're already past it. In another sense, we're getting ahead of ourselves because this doctor has not been up to testify yet. So his involvement is really not up for issue quite yet. Yeah, what's happening? Good question, good observation. That's why I was trying to listen close to make sure I understood what was happening. But basically, it's just the judge takes these opportunities to, actually I keep this at 1.4, takes these opportunities while the jury's out to just ask both sides about some pending issues that are going on. And it sounds like there's some pretty major discovery issues that were happening between the two. And that's why he finished off that segment by saying, basically, y'all two need to work better together. And I would fully agree with that statement. It sounds like there's been very poor communication between the two sides. And so now there's issues that are happening in court on the day of trial because things were not finished and resolved beforehand, which is why, especially in civil litigation, but criminal too, like you really try and get the stuff hammered out ahead of time so you're not wasting time in court doing the stuff that should already be solved. So that's the main point of that little back and forth between the judge and the lawyers.
All right, welcome back, everyone. We're back in the record on Alice matter. Counsel and the parties are present, as are the members of our jury. Ms. Ellis, you're on the stand, and you're reminded you're still under oath.
Yes, sir.
All right, you want to resume your cross-exam?
Yes, sir.
All right, we back, baby.
Okay, let's back up just a little. So, on that date in February 2018, when you were on duty as a security guard, you were wearing black boots, right?
Yes.
And you testified earlier when your counsel was asking you questions that you had an earpiece and you were checking voicemail. Well, I'm sorry, I mistake. That you had an earpiece in your head when you saw Cardi B, right?
Yes.
And you were, but then in the incident report, we saw that you wrote that you had your phone to your ear, correct?
Okay.
Is that correct?
That's what it says on the paper, yes.
Yes. And if you look at that incident report at the very top, it says from Amani Ellis, Amani Ellis at gmail.com. That's your personal email account, right?
Yes.
Well, there's a big point. If she's saying she doesn't have access to her, she made it sound like it was a work email that she doesn't have access to anymore, which fair enough. You know, I used to be a district attorney. I don't have access to my state email anymore, but from what it sounds like there, they just pointed out, wait, that's not a work email. That's a Gmail account. That's your personal Gmail account, actually. So what do you mean you don't have access to it?
And is doing incident reports a normal practice in the security guard business?
When something happens, yes.
In fact, you do daily activity reports as a security guard.
Yes.
So the reports are very important, right?
Yes.
And in the incident report, when you were reporting back to your supervisor, you said that you were checking your voicemail, right?
That's what the email says.
The email that bears your name, right? Reporting on the incident that you have sued over.
Okay.
Is that correct?
Yes.
Okay. If we could turn in the blue book to file exhibit 200.
Exhibit 200. Oh boy. What happened to 1 through 199? Also, whose phone is
Yes.
going
And
on?
that's a letter from your lawyer to me.
Okay.
Is that correct?
Yes.
And if you go to the page that has a lot of blacked out entries, is it correct that that is a portion of your T-Mobile invoice, including for February 24, 2018?
Yes.
And you see that at 1:30, you received a call, and that lasted, what, 22 minutes?
Objection, Your Honor. The document does not say 1:30.
Maybe my glasses are, I need to get a new prescription. Do you see the entry? It's 1:10 p.m. for 22 minutes?
Yes.
Okay, that was a phone call that you received and talked on the phone.
Interesting. He felt real good about that objection. Objection! It does not say 1:30. Oh, sustain. Apparently it says 1:10. Okay.
22 minutes?
Got him.
Yes.
Okay. And at 1:40, you made an 8-minute phone call?
How do we decide what your exotic car?
Let's see. The that's what it says argument is so. Is that a thing? I mean, kinda. Yeah. It's you can't force someone to testify to something that they supposedly can't remember. So if she's saying I don't recall or that's what it says, it's like it's one of those things where the court's not really going to admonish her to stop saying that. But honestly, as a defense lawyer, I'm fine with that because it's just making her look ridiculous to the jury, I think. Like these are obvious, clear, indisputable facts. Like this is your name, this is your email. And you're going to sit there and say, I don't recall, or, well, yeah, that's what it says, but I don't remember writing that. It's like, girl, did someone else write it? Did you get hacked? Then if not, then okay, what are we doing? Are you disagreeing? Are you saying this is not you? And if not, then okay, let's just acknowledge that this is yours and move on. But yeah, so the that's what it says argument. Yeah, technically yes, they're allowed to do it, but I'm okay. I'm okay with the complaining witness, the plaintiff, looking increasingly uncredible and unreasonable to the jury. Yeah.
Yes.
Okay. And whose phone number is that?
Which time are you referring to?
310-403-3656.
I'm sorry, can you say that again?
Yes, absolutely. I apologize. 310-403-3656.
I don't know who the number belongs to, but it's probably a family member of mine.
Is that Nicholas Jackson's phone number?
Probably yes.
Okay, so we're establishing she was on the phone with apparently this Nicholas Jackson at the time the incident occurred.
Can we go back? And you testified that you said when you saw Cardi B, you said something to the effect of, wow, that was Cardi B.
Something to the effect of that.
And at that point, as a security guard, you knew it would have been improper for you as a security guard to tell people that Cardi was a patient at a medical facility, correct?
I didn't tell anyone that I saw her.
Could you please answer the question now? I can repeat it if you like.
Okay.
Isn't it true that as a security guard who'd been trained, as you said, and worked for 4 years, you knew it would have been improper for you to tell people that Cardi B was a patient at a medical facility?
Objection asked and answered.
Well, yeah, she objection asked and answered. It's like she literally said she didn't answer the question. That's why he had to state the question again, so she would actually answer it this time. So it was asked, but asked and not answered maybe. So, but yeah, there's no objection for asked and not answered.
It would be improper, but I did not tell anyone I saw her.
Move to strike everything after improper.
So maybe I just want you to answer the question, okay?
Oh.
If you can answer the question with a yes or no question, please answer yes or no.
Yes, Your Honor.
And you understood when you saw Cardi B that she thought that you were using your phone to tell people that she was at a medical facility, correct?
Yes.
And as I understand it, you deny that you used your cell phone to photograph or film Cardi B on that day. Is that correct?
That's not true. I didn't record her or film her.
question was, is it correct that you denied using your personal cell phone to photograph or videotape Cardi B on February 24, 2018?
Yes.
Is it improper because of HIPAA, her job, or both? I'd say both. Yeah. Obviously, HIPAA kind of applies to anything medical. You always have to keep that at least in the back of your mind. But probably even more compelling is going to be the job. I mean, think back to, once again, it seems like the Tory Lanez case is what everything in these types of cases, an example of it popped up in the Tory Lanez case. Specifically, Kelsey Harris's bodyguard, Bradley James. Remember how supposedly he swore into an affidavit stating he overheard Kelsey admitting to being the one that shot Meg, and he overheard her say that during the trial. But he didn't come forward and share that for a solid 2 years because he took his obligation seriously as a bodyguard for celebrities, that he's just not going to go around spilling the business of the people that he's hired to protect, because you got a reputation to protect as a bodyguard. You need people who are going to hire you to believe that you're not going to go spilling the beans on them. So yeah, when you're working security in a town like Hollywood, then yeah, I would imagine it is part of the training to not go around spilling the business, especially when you're in a sensitive place like a OBGYN clinic. And Cardi B, I think this was her first pregnancy. So it's, yeah, absolutely. This is the exact type of security guard that needs to not be spilling the business. And she's saying she didn't tell anybody, but if you're on the phone with somebody at the time you're seeing a celebrity like Cardi B and you recognize it is Cardi B, which she already testified to, she knew who she was and acknowledged, I believe she said, like, either said to herself or she thought to herself, dang, that's Cardi B. That looks like Cardi B. So, yeah, is it really such a stretch to believe that she might have said, when she's on the phone with somebody, she sees Cardi B, she doesn't say, hey, that looks like Cardi B. So, but yeah, I'd say probably through her training is more likely. So basically he's framing that she should have known better. Yeah, no, absolutely. She should have absolutely known better, especially when you consider it was Cardi B today, but who's it going to be tomorrow? Rihanna? Katy Perry? Like, who knows who's going to come through these OBGYN clinics? And yeah, your confidentiality is really, especially in a town like Hollywood, man, where there's just so much paparazzi everywhere. And as these celebrities, I would just be so sick of it. Sick of people trying to get up on you and take photos, take videos, and try and pretend to be your friend. It's like, yeah, it would just get so tiresome over time. So yeah, she definitely should have known better. I would argue definitely against her training to be spilling the beans on any celebrity that's coming through.
And isn't it correct that you don't have that phone, right? You no longer have that phone. You disposed of it. You can't show us that phone and show that you don't have any photographs or videos of Cardi B. Isn't that correct?
Yes.
Yeah, I mean, I don't have my phone from 7 years ago either.
Rather than simply leaving, you stepped out of the elevator and told Cardi B to repeat what she said. Say it again. Isn't that what you did?
No.
Well, if you look at the incident report.
Uh-oh, back to the incident report. Here we go.
Quote, you see in the second paragraph? I stepped out of the elevator and asked her to repeat what she said to me, and so she did, angrily putting her finger in my face and yelling at me. Do you see that?
I stepped out of the elevator to clarify.
Oh.
And you told her to say that again, right?
I don't remember saying say that again.
Oh, so you don't recall what happened. You get pointed out. See, this is why, these contemporaneous statements are so valuable. Because now you're holding it up to her and say, you said in the report that you stepped out to clarify, or to say that again. And now her answer is all of a sudden changed from, I don't remember what happened, to, oh, I remember now. I did step out of the elevator, but I stepped out to clarify. Clarify what? You mean clarify what she just said to you? Crystal Nicole, LOL, she lying. Honestly, this is that's the vibe I'm getting. You know, we all know our girl Cardi. She's a little bit out there. This definitely sounds like something she would do as far as getting in front up with somebody and getting into a fight with them. Would not put that past her. But to paint this Amani Ellis as the innocent victim here, so far is seeming like a stretch, especially when we're talking about if she is admitting now she stepped out of the elevator. If the elevator was really closing and it was about to end the confrontation completely, she stepped out of the elevator to continue the confrontation or escalate the confrontation, then absolutely she was an active participant in this back and forth. So this is really, this part of the testimony is very, very crucial in establishing, she's not just this innocent victim who was just brutally accosted and assaulted out of nowhere for no reason at all. Yeah, this is really, to clarify who the F she was talking to. Yeah, no, exactly right.
And your testimony was that you and Cardi B yelled at each other for 30 seconds?
She yelled at me. My voice was firm because I was upset.
Are you denying that you testified at your deposition and statement to Dr. McKenzie that you were yelling and cursing at Cardi B?
I'm not denying it. I just wanted to clarify.
And as you were yelling at Cardi B, people stepped out of her doctor's office. One of them stepped in between you to separate you two. Isn't that correct?
Yes, because she was in my face.
And the people came out of the women's care doctor's office?
I mean, was she in your face or were you in her face? Or more likely, honestly, the truth is usually somewhere in the middle. They're probably in each other's faces. Let's be honest. That's probably what happened here. So really, they're both at fault. But when they're both at fault, then nobody gets anything. That's what I would say. But yeah, using the truth against them is such a good strategy. Yeah, no, exactly right. Exactly right.
Employees came out from the 5th floor. I would assume they were from women's care.
And the woman who stepped in between...
There should be plenty of witnesses too. So it sounds like there were a lot of people there. So I'd be curious to hear what the witnesses have to say about what they saw.
Came out of that office?
I believe it was her, yes.
And you testified in your deposition that Cardi B spit at you after the other people came out of the doctor's office. Isn't that correct?
She did.
Move to strike as non-responsive. And if
Why don't you just clarify the question?
you testified at your deposition under oath, you said at that point that Cardi B spit at you after the other people came to intervene in the argument. Isn't that correct?
Yes.
And yet, in the report, you state, I advised Cardi B that she needed to get her finger out of my face because I had not did anything to her. She then responded by spit at me. That's how it's spelled. And as a result, I became angry and yelled out to her to leave me alone and go on about her business. A few moments later, I remember a few people coming out and trying to separate us. That's what you said in your email, correct?
Correct.
Once again, inconsistency. It's it seems like a small one, but yeah. If you're saying, you advised her to get her finger out of your face and then she spat on you and then people came out versus now your deposition, you're saying people came out and then she spat. Once again, we're just stacking these up little by little, brick by brick, and eventually you're building up enough. Usually in the criminal world, we're saying you're building up enough to get to your sizable enough mass of reasonable doubt, building a big enough hole to call it reasonable doubt. But here it's preponderance of the evidence. So it is a lower standard, it's just more likely than not. But you can still get there. You can definitely still get there. So let's see. Holla. What's up, Jay Mizak? Welcome to the stream. Welcome back, I should say. You were a trooper in the last one. But yeah, being a security guard with an emotional response is a bad looking move, in my opinion. It's like the one business, that and maybe being a police officer, but they're similar to each other. You want to, just keep your wits about you. Be reasonable in a situation. So yeah, dangerous, absolutely. And I think they both line. Honestly, yeah, that's why I kind of mentioned earlier. I think you just missed it, but the truth is usually in the middle of every story. I think they were both instigating. They're both in each other's faces. Yeah. Have you heard any medical reports yet about Scratch? Not yet. All we've heard so far, she's the first witness that was called. She's the plaintiff. So it's just her getting her story. And plaintiff's lawyer did, I thought, a terrible job trying to get through her stuff, just bouncing all over the place like a pinball. But now we're on cross-exam, and the defense lawyer is doing a really good job impeaching her credibility and pointing out inconsistencies. So, so far, definitely the better lawyering is coming from the defense.
And you stated in your incident report that Cardi B's nails were 3 inches long that day?
They were.
Your Honor, if we could ask for an admonition for the witness to answer the questions I'm asking.
See, I feel like as security, she has a duty to approach Cardi if she was acting wild. I agree, but the question here is, what is the evidence that Cardi was acting wild? Because basically what we got established so far for the story was Cardi was there for a medical appointment for her pregnancy. She saw the security guard with her phone and felt like she was being recorded and had her business being spread out. And so she either made a comment or she confronted her. Something happened. They end up in each other's face. It sounds like she probably made a comment to her as the elevator was closing, because then we heard the plaintiff here admit that she herself got out of the elevator to, in her words, clarify what was said. And I think a reasonable take would be to further instigate the situation. But Yeah, but not if she's following her for a reaction. Yeah, she doesn't have a duty to act like she's an equal when she's on the job. Yeah, I think I would agree. If Cardi's kind of just acting like wilding out for no reason, then yeah, security guard, that is your job to kind of quell the situation. But it sounds like security guard was kind of the reason for Cardi to maybe act out initially, but then she didn't like the way she acted out, and now they're in each other's faces and they're yelling and screaming, and yeah, supposedly getting assaulted. So yeah.
Please just focus on the question and answer the question as asked.
Yes, Your Honor.
And the question is, you claimed in the incident report that Cardi's nails were 3 inches long that day. Isn't that true?
Yes.
And you testified at your deposition that Cardi pointed her fingernail at your face, right?
Yes.
And you state in your February 26, 2018 incident report, bear with me for a second. I'm sorry, I have a marked copy of this one. I didn't bring it with me. You state in your incident report that she scratched you on your nose, right?
Objection, misstates the testimony of the witness.
Oh, it's contrary to it. Sorry.
Yeah, there's no objection there. If it's a prior statement she's made, you're allowed to impeach her, especially if her testimony today is she got scratched on the cheek and there's a scar on her cheek. But now if her incident report at the time was that she got scratched on the nose, that's kind of a big detail here.
You testified.
Which I could see why why her lawyer is trying to object, just to find some sort of grounds to not have that evidence come in. But of course, yeah, it's getting overruled 10 times out of 10.
In this trial, that Cardi B cut your cheek. Yet you stated in your email to your supervisor on February 26, 2018 that Cardi B cut you on the nose. Isn't that true?
Objection, misstates the testimony.
Yeah, he's trying.
She put her finger in my face.
He is trying so hard. Her lawyer is trying so hard to keep this part out.
Okay, first of all, you have testified here today under oath that Cardi.
Are you LLC?
Yeah, I mean, understandable. This is really bad. This is really bad for the plaintiff here.
7 years later, that Cardi B cut your cheek, your left cheek. Isn't that true?
Yes.
And you state in your report 2 days after the incident that she scratched your nose. Quote unquote, third paragraph. At this time, she continued to yell at me and point her 3-inch acrylic fingernails into my face, scratching my nose. You see that?
Yes, but into my face.
You have to strike out everything after yes.
Over. Motion denied.
And you were clear at your deposition that you had changed the story to Cardi supposedly cutting your cheek, not her nose, right?
No.
You specifically testified to that, didn't you?
I'm not sure I know what you're asking.
At your deposition, you specifically testified that you were not scratched on your nose that day, you were scratched on your cheek.
She touched my nose, but she scratched my cheek.
Okay, but in the incident report, you state scratching my nose, right? You have to answer audibly.
Yes, I'm sorry.
Professionalism out the
In fact,
window. Yeah.
You demonstrated at the deposition how
We can see why she did not continue her work as a security guard after this.
Cardi B supposedly was nose to nose with you, but jabbed your cheek. Is that true?
Yes.
And if we could show that. This is a video of the deposition where plaintiff demonstrates how she
Sorry,
was
she just
scratched
lying to be
on the
lying.
cheek.
Feels like it. Feels like it.
That's the deposition video.
Hey, she got 24 million reasons to lie,
You
man.
have to identify the page and month.
Well, we'll have to come back to that because I don't have that. I have the deposition video. Actually, well, I don't know things up. We'll do that a little bit later. And you admitted at your deposition that there was no scar on your nose, right?
I'm not sure.
Well, we can play that back for you if you like. But did you testify at your deposition that there was no scar on your nose?
I'm not sure.
We're working on that. And in your response, your verified response to the written discovery that was served on you in this case, and specifically the special interrogatory, interrogatories number 1, 3, 5, 7, 9, 11, 14, 25, 26, 27, and 28, that Cardi beat you about the head, face, and body. Is that what you did?
I'm objecting because I don't have the number of special rod he's talking about, the set and the date.
I haven't used it yet.
What he's asking or not, I want to know what he's talking about.
Why don't you break it down?
I'm sorry, Your Honor?
Why don't you break it down to the specifics?
Okay.
Sure. Right.
Well, in light of counsel's objection, I can show the witness.
Oh, that might be faster if you just read the interrogatory and the response.
Trying to ask her questions about the interrogatories.
The counsel, plaintiff's responses to defendant Cardi B's special interrogatory, set number 1.
Is that dated 2022?
Yes, sir.
August 9, 22?
Sounds like the judge
Yeah, that's right.
is really wanting wanting the lawyer to establish, when you're going through the discovery documents like interrogatories, to establish the title and the date. Let's make sure everyone's on the same page, looking at the same
if I
thing.
can direct you to interrogatory number 1 at page 4.
All right, what do we think, chat? What do we think about the style, the fit, the hair? Let me know.
Sorry, it's a long one. I'm trying to. I mean, I don't want to hold this up, so I'm going to have to go back to it because.
Just can't take this
somewhere
case
it's a long,
serious.
long
Yeah.
thing of a page and a half. There.
I wasn't planning on covering it. I saw this as maybe the next Johnny Depp Amber Heard. Take like 3 weeks to litigate, but when I saw the evidence got through in 3 days, I'm like, oh, absolutely, we can watch the entire thing and get done just in time for the closing statements on Tuesday.
The interrogatory.
Hate the hair. Oh boy.
The response states, and among other things, in specific, on or about February 24, 2018.
Not rocking with the
plaintiff was often
pixie.
working as a security guard on or near the premises of the subject property when defendant Nicholas Marlenis Almanzar assaulted and battered plaintiff by violently, unlawfully, intentionally, suddenly, and maliciously striking her about the head, face, and body. Do you recall swearing to that under oath?
Yes.
No.
Sounds like her statement when asked in the interrogatory, her statement sworn was that she was battered about the head, face, and body. So already you can see the inconsistency there of, oh no, actually it was just a scratch to the cheek, which might have been the nose, but now I'm not saying it's the nose, now I'm saying it's the cheek, but definitely not to the head, face, and body, just the cheek. Yeah, that's the thing when you're a plaintiff, when you're trying to prove a case, consistency is key. Try to have a consistent story all the way through.
Back to the way you demonstrated this alleged assault on your cheek at your deposition. If we could please play the video associated with 55 minutes 9 seconds to 56 minutes 6 seconds.
Is there a question and answer?
Oh, those are pages in line. I'm sorry. Page 55, line 9 to page 56.
Let's
line
see.
6.
Not convinced security was the aggressor given Cardi's history, videos, and so much. I think Cardi pushed the guard to act that way, not excusing her behavior in totality, though. I'm not going to disagree. I mean, we've all seen the clips. We know Cardi B's history. Was it Love and Hip Hop? That was the show. Definitely would not put it past her that this is her background. However, I will note, though, a lot of that is improper character evidence that was not allowed to come into this trial. It was actually excluded by the judge, excluding any reference to her past history, song lyrics, past TV shows she's on, because he doesn't want the jury to be improperly biased, because just because someone has a tendency to act in a certain way doesn't mean they acted in that way on this occasion. The burden is to prove through evidence from this occasion that what is alleged to have happened actually did happen. And just because you want to hold up someone who did a bunch of bad things in the past, you don't want to bias the jury and poison the well like that to get them to try and hold the person liable based on their history instead of the facts of this case. So, but yeah, I'm not going to disagree. I definitely think Cardi was not an innocent actor in this entire exchange either. My read on it is that they were both probably equally culpable in this. So, I think security was the aggressor. She followed her and was allegedly recording her while at doctor's office, where she should expect some privacy. Yeah, I mean, certainly, if that's the feeling, the question becomes, is that a reasonable feeling on Cardi B? As someone who's probably does get followed by paparazzi, I'm sure she is kind of on high alert for this kind of stuff. But honestly, this also probably sounds like it was just a miscommunication to begin with. But unfortunate that it's taken us to this point. But I mean, here we are. So it's given us an opportunity to hang out together.
When Cardi put a finger in your face, where in your face was it?
She struck me on my nose and on my cheek. She wears her nails very long, very bedazzled, very sharp. So yes.
And you said it made contact with your nose?
Don't they say that when people kind of twist and fidget in a chair like that, like moving back and forth, don't they say that's a sign of not being truthful? I think.
Yes, and my face.
And
like
so
you're uncomfortable.
2 times she touched you?
Yes, so she was like this.
When you say like this, she put her finger?
Pointing, yes, so like this, pointing her finger at my face, yes.
And it touched your nose?
Yes.
What part of your nose?
Whatever part of the nose that the nail landed on, yes.
Oh, I mean, it was at the bottom, the middle, the top?
I'm not sure.
And which cheek did she touch?
My left cheek.
Do you remember giving that testimony?
Yes.
And if you need a moment, you can look at the incident report, but isn't it correct that in the incident report, you made no claim that Cardi struck you about the head and body?
I put in the incident report that she had her finger in my face and she struck my face.
But not that had her
She
body.
your nose, right? Isn't that what you put in the incident report? That she scratched your nose. I can read it again if you like.
I don't need you to read it. I'm not sure.
Is there anywhere in this incident report that you prepared and sent to your supervisor 2 days after this alleged incident that you said that Cardi struck your body?
And the incident report says that she struck me, yes.
Where?
It's in the paper.
I'm sorry?
It's in the report. I reported it that she had her finger in my face.
Can you read it?
I understand that, but let's set aside putting your finger in your face. Let's set aside supposedly scratching you on your nose that time. That was what he's saying. Is there anywhere in the report that says that Cardi on that day struck your body?
I'm not sure.
Can you take a moment and look through it?
She's gonna look up in like 10 seconds. And look, she's doing the chair tilt again. Hold up, let me look this up.
As I'm reading it, I reported that she put her 3-inch fingernails into my face. So that's what I remember reporting.
Well, let's be accurate. I mean, the truth is important and accuracy is important. This report that you did 2 days after the incident claims that she put her 3-inch fingernails in your face and scratched you on the nose, right?
Yes.
Okay, so let's talk about immediately after the accident.
Well, Your Honor, I'm going to object. You said in the face, but the document says into the face. There's a difference.
Why don't you clarify the question?
In the incident report, the only scratch that you report is a scratch on your nose that you supposedly suffered that day, correct?
I'm not sure.
Do you need another moment to look at this?
I reported that she touched my face with her finger, sir.
Ma'am, the question is, in your incident report, you told your supervisor 2 days afterwards that you suffered a scratch on your nose and no other scratches were mentioned, correct?
Okay.
What does okay mean? You agree?
I don't know, y'all.
I don't agree with what you're saying, but I'm saying okay for the
Same.
purposes of your question.
Yeah, I'm not quite sure what that means, but let's move on. After the incident, you don't even know if there was any
Just
blood.
saying.
It broke the skin.
Please, ma'am, just answer the question I'm asking. You testified at your deposition that you did not know if the alleged scratch, this time on your cheek, even bled. Isn't that true?
Correct.
And you didn't go to a doctor that day for this alleged assault and battery, did you?
I saw a medical doctor, but not at the day of the incident.
Okay, again, let's focus on the questions I'm asking you. You allege that you were assaulted, battered, beaten up, scratched somewhere, sometimes on the nose, sometimes on the cheek, and you went home and took a nap, right?
I was
That's what you
upset.
testified
Yes,
at your deposition.
yes.
Okay. Maybe called your mother, right? That's what you testified to, right?
Yes.
You didn't call your grandmother, though, did you?
No.
You never even put a Band-Aid on this alleged scratch, wherever it was, did you?
Objection calls for speculation.
No.
When your counsel was asking you questions today, he said that he basically elicited testimony from you that since you didn't think you were going to sue, you didn't take any pictures of your alleged injury in February 2018. Isn't that what you testified to?
Yes.
At your deposition, though, you testified you took pictures that day, and you can't find them. They disappeared somehow. Remember that?
I'm not sure.
Okay, so I would like to
Play it back.
recognition. Well, first of all, let's start at page 69, lines 18
Roll the
to 20.
tape. Deposition time.
Yes, I would ask that you read both before and after, not just the specific lines of
Give me the pages and lines one.
Because yeah, this is what I'd be looking at if I'm looking at if I've got a plaintiff that's come to me in a situation like this, and I'm trying to give them a realistic estimate of what their chances are. It's like, well, did you take pictures at the time? Who'd you tell at the time? Did you go see a doctor at the time, or at least go get care done? It's everything at the time. Especially we're talking about 7 years later now. The contemporaneous accounts are going to be very reliable, at least more reliable than your recollection now, 7 years later, when you got 24 million reasons, supposedly, to spin a story that is going to redound to your benefit. So, yeah, the fact that we apparently, as she said, she took pictures, but now she doesn't know. I think I remember seeing a picture in one of the clips, though, so I guess we'll see what happens. But, yeah, a nap. Yeah. How do you need cosmetic surgery for a scratch that wasn't even bleeding? I don't know. So I'm very curious to hear what the plastic surgeon has to say. That'll be in the later streams. We're just doing day one today. We're making good progress. So I appreciate y'all being here, of course. If you haven't yet, go ahead and hit the like button down below. It's much appreciated. It lets me know that you like this kind of content and coverage on this case. So, yeah.
Give me a copy of that.
Not every day we get such a high-profile case that gets fully streamed and is relatively short.
I don't see any objections. Go ahead.
Did you take any pictures of your face at the time?
I did take pictures.
Okay.
Roll the tape.
There's several other examples where you testified that you took pictures, but somehow you just don't know where they are. You took pictures of the cut, that you supposedly suffered after this, or during this alleged assault. And you took pictures way back in 2018, but somehow can't find them. Is that what you
That's right,
testified?
Jamie
Yes.
Zach.
And you testified when counsel was asking you questions that you decided you didn't want to be a security guard anymore. Isn't that true?
Yes.
In fact, you were fired. Isn't that true?
Objection, Your Honor. We discussed this at length.
Isn't that the truth? You were actually fired by Allied for acting unprofessionally as a security guard. Isn't that true?
Same objection.
Yes.
Boom. Following Sense first vid, I'm Meg Tory. Rarely get to catch a live. Oh, well, you know, I've just started the live streaming stuff. You know, this is the second stream I've done. Still learning how to make the experience better, but so far I think we're doing a pretty good job. So I got the chat pulled up live so y'all can see yourselves. Everyone likes to see themselves, of course. So yeah, no, we're rock and roll. I appreciate you being here, Tara Isms in my mind. It's yeah, no, you're helping the stream out a lot by being here and being talkative. So no, it's awesome. Love to see it.
And in the incident report, you apologized to your employer, Allied, for acting unprofessionally and exposing them to potential liability. Is that true?
Okay. Wait for it. Okay. Start right now. Okay, everyone put your prediction down. What's she going to say? Is she going to say okay? Is she going to say sure? Is she going to say that's what it says on the paper? Those are three options. My bet is okay. I can feel it coming. I feel it bubbling up. You can see it. It started down here. It's starting to bubble up. It's in her throat right now. It's about to come out.
What's her answer?
That's right.
What's her answer?
No, I guess we didn't report, but if it helps me, I can direct her to the second statement.
Yes.
Oh, man.
And after you were terminated as a security guard, you got a new job to make more money.
Oh
than
gosh,
you-
we all got it wrong. We got okay, and that's what it says. Sorry, guys.
Right.
Let y'all down.
Yes.
And you said that you consulted with Dr. McKenzie, excuse me. That was because you filed a workers' comp claim, right?
Yes.
And so you filed a workers' comp claim against Allied, and that's why you met with Dr. McKenzie, correct?
Yes.
Workers' comp claim.
And you
Interesting.
met with her in April of 2018?
Yes.
And you testified at your deposition that you told Dr. McKenzie the truth about what happened on February 24, 2018, right?
Yes.
Remember what I said earlier? Impeaching credibility is all about setup and takedown. We're getting another setup right here saying you talked to this doctor, right? And you swore, or you said in your deposition that everything you told your doctor was true, right? Yes. Or I feel like we're about to get a statement that she gave the doctor that's not going to line up with some testimony that's happened already. So it's coming. The setup is happening. We're about to have the takedown.
Okay. In this action, you served, well, you were a patient of Kaiser Permanente, correct?
Yes.
And in this action, you obtained a copy of your medical records from, let's see, beginning June 8, 2023. Bear with me for a second, please. Actually, it goes back, I think, further, but have you seen those records?
I'm not sure.
Isn't it, well, I hate to ask this question, but they did diagnose you as having severe obesity, correct?
Yes.
And they did conclude that you had full capacity and no history of patient status change. Isn't that correct?
Yes.
The only pains that you complained of, January 25, 2021, December 27, 2021, were belly pain and low back pain, right?
Objection calls for expert opinion.
No, yeah, it's not an
Right.
objection.
Yes.
And you hurt your finger at one point, right?
I'm not sure.
Well, I can show it to you, but let's just move on. You had various things, tailbone pain, right hamstring pain, but you had no report, no reference in 161 pages of medical records to a scratch on your face. Isn't that correct?
Yes.
And there's no reference in 161 pages of medical records to anxiety, post-traumatic stress syndrome, blows to your head or face. Correct?
Yes.
That only came up when you filed this lawsuit.
Isn't that convenient, right? She had none of these issues at all. No scratch to the face, no emotional trauma, no PTSD. This is all based on the doctor's visit she did back in 2018. Remember, this is or 2019, I think. So this is the time that this is all happening. None whatsoever. We're good. We're cool. You know, I got some. What did it say? Some back issues and a right hamstring tightness. So yeah, we're good. We're chilling. Everything's all hunky dory. And now here we are. Oh, I've just been so traumatized and I can't sleep and I'm post-traumatic stress disorder, and I need $24 million to be made whole again. Oh, of course, now you have all these issues.
I'm not sure I know what you're asking.
Yeah, fidgety, you're right.
Also, you were in a car accident in 2021, isn't that true?
Yes. Yes.
You were in a car accident again in November of 2023 on Pico Boulevard, right?
I'm not sure if it was on Pico, but it was in that area, yes.
My gosh, 2 car accidents in 2 years? At what point are we gonna say maybe she's the bad driver? She is the common variable among these accidents. But also too, this is relevant because we're talking about medical damages that she suffered supposedly as a result of this scratch to the face back in 2018. She can't sleep. She's got PTSD. She's been emotionally traumatized. Like, okay, maybe that's true, but is that really because of this incident from 2018, or is it from these not 1 but 2 car accidents that you've been through in the last 2 years ago and 4 years ago?
You sued over that, right?
Yes.
Okay, Your Honor, if I could just consult with my colleague, I think I may be close to done.
Okay, almost there.
Team effort. If you can bear with me. We talked about how you told Dr. McKenzie the truth about what happened, right?
Yes. And
you told her that Cardi B almost scratched you. Isn't that true?
I'm not sure saying almost.
Uh-oh.
You know the person at Women's Healthcare who intervened when you were basically assaulting Cardi B, don't you?
No.
Well, isn't it true that 3 weeks after that event, you called up Tiara Malcolm, the receptionist, who put her body in between yours and Cardi B's and took your blows? You called her up to try and get her to help you in this case. Isn't that true?
I'm not sure.
Oh, you don't recall. You're not sure.
Can you just check one thing?
That's the thing. I hope this Tiara Malcolm person testifies, because that's if this person, Tiara Malcolm, inserted herself between the ladies, the girlies were fighting. Hey, once again, Tory Lane's case. It all comes back to that. The girlies were fighting. That's how these all start. Kelsey and Meg were fighting, and now here we go. Amani and Cardi B were fighting. Yeah, she's such a Kelsey. That's what I'm saying. And so you've got someone who physically inserted herself between the two. I'd love to hear what she has to say about the situation, because she's got no dog in this fight. She doesn't have 24 million reasons to lie. So she can actually share probably the most unbiased, objective opinion or recollection of what happened. So I'm very curious to see what she has to say. I hope she's a witness. Yeah.
Sorry, I want you to. I'm just double checking. I also want to just reiterate that in your deposition, you testified under oath that Cardi spit on you after Ms. Malcolm and others came out of the doctor's office to try and stop you from going after Cardi B. Isn't that correct?
Yes.
And in your incident report, you reported to your boss, your supervisor, that Cardi supposedly spit at you before people came out because of all the yelling. Isn't that correct?
Yes.
Probably be objecting for asking answered at this point.
All right.
Is that what happened?
Yeah.
That Cardi supposedly spit at you before people came out because of all the yelling. Isn't that correct?
Yes.
Your Honor, I think that's all the questions I have. All right.
I'd like to read from.
So we had direct exam, we got cross exam. Now her lawyer gets to redirect her to try and rehabilitate her, because her credibility was pretty thoroughly shot through in that cross exam. But now her lawyer has an opportunity to redirect and try and go over some of the things that were crossed on to try and get back some of this credibility that she lost here.
The deposition transcript, page 61, lines 23, page 62.
Yeah, all that's missing is a pleading the fifth every other question. So I hate to be the to rain on the parade. Cannot plead the fifth in a civil case. This is a civil case here. Fifth Amendment only applies to criminal cases, and it is your right against criminal or self-incrimination. So, yeah, as much as I would love to have seen that happen here, well, not because I want to actually get our answers out, but Although her saying "I'm not sure" over and over again basically does the same effect as pleading the fifth over and over again.
Let me turn this over to you.
Page 62, line 14.
I'm sorry, counsel, I was trying to get out. Let me take it. What pages?
Page 61 to 62. You want the line?
Yes, please.
Line 23 on page 61 through lines 14 on page 62.
All right. See if we can't get to the redirect.
Here you are. So, question. Did you fill out any written paperwork about the incident?
There you
Answer. There was an incident report made for that day. Yes. Question. When you say there was an incident report, is that something you completed? Answer. Yes. Question. When did you prepare the incident report? Answer. I'm not sure. Part of what Jasmine wanted me to do was write an incident report. I'm not sure how long after it was done. Question. Okay. When you say an incident report, is that something where you send an email or is it a pre-printed form that you complete? Answer. Normally it's a pre-printed form. We didn't have those forms at the location that I was at, so she did ask me to type it up.
Fake pleading the fifth, you're right.
Deposition, a different attorney asked you questions about this incident?
Yes.
And you did tell that attorney that you made an incident report, correct?
Yes.
And that's the 2-page email that counsel asked you about?
Yes.
And in your incident report, in paragraph 3, it states that this time she continued to yell at me and point her 3-inch acrylic fingernails into my face, scratching my nose. I advised Cardi B that she needed to get her finger out of my face because I had not did anything to her. So when you wrote this incident report, you estimated that the fingernails were 3 inches long?
Yes.
And when you said that the fingernails went into your face, what did you mean by that?
I meant when she was going like this, her nail touched my cheek, touched my nose.
Did it actually cut your cheek?
Yes.
Allegedly. Yeah.
No.
And then counsel asked you about the T-Mobile bill. You testified that this incident occurred at 1:30 p.m., correct?
Approximately, yes.
And the T-Mobile bill shows phone calls at 1:10 p.m. and 1:40 p.m., correct?
Yes.
You were not making any phone calls at the time of the incident, correct?
Objection.
I can withdraw the question. Did you make any telephone calls at the time of the incident on February 24th, 2018?
No.
Did you make a phone call 10 minutes after the incident on February 24th, 2018?
Yes.
The phone number 424-219-2078. Whose phone number is that?
I believe it was my mom.
Mom, we're gonna be rich.
Did you tell anyone that Cardi B was at this medical facility just before the incident occurred on February 24th, 2018?
No.
If you did do that, does that give Cardi B the right to assault and battery?
Objection. Yeah.
Your Honor, is the court going to take judicial notice of the complaint in this case?
I'm not sure for what purpose.
Because the discovery response that was read is verbatim as to what the complaint says?
No.
When written discovery was prepared with you, was it done by your attorney's office?
Yes.
Do you know what written discovery is?
Yes.
What does the word form interrogatory mean? Do you know?
No.
Do you know what the word special interrogatory means?
No.
Do you know request for admission?
No.
Do you know demand for production of documents?
No.
These are discovery questions that are prepared with your attorney?
Yes.
When I asked you earlier if any pictures were taken, you were truthful in your answers, correct?
Yes.
And when you answered me about whether pictures were taken, did you understand my question to be on the date of the incident?
Objection. I can't answer.
Yeah, objection speculation.
Explanation, what's this thing?
Did you take pictures of your scar or your cut or anything on your body on the date of the incident, of February 24, 2018?
I'm not sure.
Did you at some point later on take photographs?
Yes.
When? How much later on? On what context? What circumstances? For your workers' comp claim?
When you treated with Dr. McKinsey for your claim, whether it was for a work comp claim or not, were you in need of psychological care?
Yes.
And her treatment was helpful to you?
Yes.
Recross?
Yes, Your Honor. Just briefly.
So yeah, now Cardi's lawyer gets to recross. Basically, they get to keep going back and forth until both sides feel like they have asked all the questions they wish to ask. And we're blacked out again. Come on, cross-exam's the good stuff. Oh geez, this is a long one. My gosh. Hold up. Are you kidding me? Okay, well let me try the other one. I know this got streamed 2 places. Trial day 1. Court TV. Let me try this one.
Yes.
What about the cost of the treatment? Could you afford to pay $15,000, $20,000 to get plastic surgery to your face?
No.
Did Dr. Mulligan agree to treat you on a lien basis?
He did.
And when you got medical treatment on a lien basis, is it your understanding that regardless of the outcome?
No, that was
I'm asking
from
you about the
earlier.
response. You made a discovery in this case, stating that under oath you have no emails that relate to this incident.
Yep, okay.
Well, that's correct. I don't have access to this email anymore.
Alright. Oh, did it go out for everybody? Uh-oh.
All right, folks, before we head back to court, let's bring in family and trial attorney Scott Freeman, who joins us this hour. Scott, thank you so much
no,
for joining
bring us back to court.
Were you talking to anybody at that time?
No.
For sure.
Yes.
Were you entering the elevator?
I was, yes.
Did you actually go inside the elevator?
I did, yes.
And did Cardi B exit the elevator?
She did, yes.
Okay, and then what happened?
After she heard me say her name.
Sorry, y'all. How hard is it? I swear, when I was a DA, I was like the tech support for my office because these people didn't even know how to play videos on the screen in the courtroom sometimes. Like, really easy.
I was at work on duty as a security guard.
Where were you?
The address of the building was 8920 Wilshire Boulevard.
And for how long had you been working as a security guard as of 2018?
For 4 years.
And what did it take to become a licensed security guard?
I think this is just a recap of the original direct.
And did Miss Cardi B, after this incident, post different things about you to her fans?
Yeah, they're just playing the direct again. Well, dang. Well, I was expecting this to go a lot longer, but I think that's kind of it. That's all we could really do for the day, because we just lost the complete rest of it. What do the comments say? Let's see. Actually, yeah. I bet this girl never thought this would make the trial. She's hoping Cardi would settle out of court. But if we know anything else about Cardi B, she is a fighter, not a lover. Maybe she's a little bit of a lover sometimes when she wants to be. But, oh yeah, she was like, nah, this girl crazy. Let's take it to court. Being assaulted by a celebrity having no single pick of the injury isn't crazy to y'all? Yeah, I mean, it's gotta be probably the biggest day of your life. One would think. One would think. PTSD, sleepless nights, depression canceled her dream to be a police officer, but no documentation or memory whatsoever. She's a liar, and it's so obvious. How many times has she been caught in a lie already? I hope she gets stuck with all Cardi's legal fees. Alright, well, we see where the... Yeah, coming to court this unprepared is crazy. I wholeheartedly agree with that, because I don't know what the beginning of that direct exam was. Oh my gosh. Lawyer was all over the place, man. Anyway. Oh, here we go. But then it goes out. Yeah. Well, I guess that's kind of it. There's not much more to do for day 1, which sucks. But yeah, I think. Oh look, Hey, I know that guy. She's cooked. Yeah. But yeah, anyway, well, let me do this then. Let me go boom, boom. Yeah, well, I'm still good to hang out for a little bit. Chat with y'all. I know y'all can't, well, how do I want to do this? I'm gonna keep it like that, actually. Yeah, no, actually, I'm just gonna wrap it up there, because my woman is awaiting for me. She was going all the way through. Probably, if you look at the playback, you can see her right there, where that's a little entryway from the kitchen over to the hallway, down towards the bedroom. So she swears she don't want to be on camera, but yeah, y'all probably don't even think she's real. But I promise. She's not just my girlfriend, she's my wife, and she's not Canadian. But yeah. Anyway. Well, I hope y'all enjoyed. Yeah, that's largely going to do it. I can see people starting to sign off. So yeah, we're going to call it there. Very much appreciate everyone who came through. Congrats on your marriage, by the way. Thank you so much, it was a lot of fun. Had a lot of fun getting married, going on honeymoon. So but yeah, we are back now. I saw her a few times. Go cuddle, LOL. Oh, I will tell her you said that. But yeah, so the plan now, since I think all I got left over are my real troopers that I know are going to be there on the next one. Yeah, day 2. We're going to be doing that. The plan is to do that on Sunday. Sunday afternoon, probably like maybe 2 o'clock-ish we might be starting, 2 o'clock Eastern time. I know day 2 is a lot longer it's a full 8 hours of testimony. It's got its breaks in there for lunch breaks and whatnot. But yeah, so we should be able to get through it a little bit faster than that, especially too. Some of the witnesses are going to be a little bit redundant. The real, star witnesses are going to be the plaintiff. Obviously, Cardi B is the defendant. The doctors, I want to hear what the doctors have to say, and any witnesses that were there that are willing to testify about what they saw on that day. So that's what we're going to do. Plan for Sunday, 2 o'clock. I'll be putting that up on Twitter, letting everybody know. By the way, if you're not following already, go follow there. That's where I make these announcements. Also, best thing you can do to be notified of when I'm going live to stream, of course, the Twitter follow, but also on YouTube, if you can see down by the name, if I let me pull up my own stream so I can
booking a flight
correctly identify. Yeah, so down by my name, if you click the little bell next to the name, that's the notification bell. That will give you a notification anytime I go live. So in case you missed the Twitter post, the X post, then at least you'll get notified through YouTube directly, through your phone or whatever you usually watch YouTube on. Yeah, you'll get notified, and that way you won't ever miss the live streams. Yeah, the plan was to do them once a week, but I really wanted to get through all this one before next Tuesday when they do closing arguments, so we can be fully caught up and we can make our predictions. So yeah. But yeah, that is all I'm gonna have for today's video, today's live stream. Once again, thank you all so much for being here. I will say my goodbyes now, and I will see you all hopefully on Sunday, and if not, Monday we'll do day 3 of the trial. So, but yeah, y'all have an awesome night and an awesome day tomorrow, and an awesome long weekend, Labor Day weekend, and I hope to see y'all a little bit later. So, good night, everybody.